Hi, I'm Pam MacEachern. I'm a family law lawyer with the Ottawa law firm of Nelligan O'Brien Payne. I've been practicing family law for about 20 years, and today I wanted to talk to you about matrimonial homes and the special provisions that relate to them. These are important to know because it can make a big difference on your family law rights both within the marriage and in the event of a marriage breakdown. Most people in Ontario believe that there are special protections that apply to the matrimonial home, and this is correct. The Ontario Family Law Act does make special provisions for the matrimonial home. Now, the first thing to know is that these only apply to married spouses in Ontario. Common law spouses in Ontario don't benefit from these special protections. Some of these special protections include that under the Ontario Family Law Act, a married spouse has a right of possession of the matrimonial home, whether or not they're on title. That means that they can't just be kicked out of the matrimonial home. They can only be forced to leave if there's a court order or if they've signed an agreement that requires them to leave the matrimonial home. A second protection is that a married spouse can't sell or mortgage the matrimonial home without the consent of their spouse. And a third protection providing to the matrimonial home is in the manner that property is equalized between married spouses. Special protections apply to assets that are in the matrimonial home, and that means that assets that may otherwise be excluded from property sharing between married spouses, if they end up in the matrimonial home, are not excluded. That makes a difference if you own the matrimonial home on the date of marriage, or if you receive money from a third party through a gift or through an inheritance that is invested in the matrimonial home. Many spouses believe that they're entitled to half of the value of the matrimonial home in the event of a marriage breakdown, whether or not they're on title. That isn't true. That's because married spouses are entitled to an equalization payment in Ontario, and that equalization payment is calculated by looking at the value of all assets and debts accumulated during the marriage by both spouses. It doesn't just look at the matrimonial home. So the matrimonial home may result in one spouse owing the other person an equalization payment, but you need to look at the value of all of the assets and the debts. It's not just an entitlement to half of the value of the matrimonial home. Many spouses also believe that it doesn't matter who's on title to the matrimonial home. That also isn't true. If the matrimonial home is owned on title by one spouse and not the other, then in the event of a marriage breakdown, the spouse who owns the home is the person who keeps the home. In Ontario, the right to an equalization payment doesn't change home ownership. So the owner of the property gets to keep that property, although they may owe an equalization payment to the other party depending upon how other assets and debts are held, including the matrimonial home. If you're thinking about how ownership of the matrimonial home should be held, or you're thinking about taking an inheritance or a gift from a third party and investing it in the matrimonial home, or if you own the matrimonial home and you're about to get married, you should talk to a family law lawyer and get some legal advice about how different ways of dealing with the matrimonial home can impact upon your rights both during the marriage and in the event of marriage breakdown. Thanks for listening to me today. If you're looking for more information on the matrimonial home or the equalization payment or on protecting yourself and your assets, please visit our website at nelligan.ca.